be standing here once again at the International Lawyers Association's annual conference as your host. For those of you who have attended our annual conference in years gone by, you will know that this is not only a time for us to bring our members together, it's also an opportunity to discuss matters that are of significant interest to the legal profession. The theme for today is the core principles and duties of legal practice. And we're better to discuss this topic than in the heart of legal London, in the Law Society building itself. The Law Society was founded in 1825, and for 200 years, it has been dedicated to representing, supporting, and promoting solicitors. For centuries, they have been advocates for the rule of law and access to justice for everyone, while also focusing on promoting excellence within the legal profession. As lawyers in the UK, we are all too familiar with the core principles of legal practice, which revolve around integrity, honesty, competence, confidentiality, and the duty to act in the best interests of the client while upholding the rule of law and maintaining public trust. It is often said that being a lawyer is not just a profession, it's a way of life. Abraham Lincoln once said, "Discourage litigation, persuade your neighbors to compromise wherever you can." As a peacemaker, the lawyer has superior opportunity of being a good man. There will still be business enough. Through our key speakers this evening, we aim to share knowledge and experiences. I know the audience today is full of great legal minds who have a number of accolades to their name. But we hope that each and every one of you can take away something of value and even be inspired to improve on the inherent personal strengths we as lawyers possess. It is on that note that I would like to call our first speaker, Mr. Sajjad Kiani. Mr. Kiani is a principal solicitor at Kiani Legal, a law firm based in Ilford. He was first called to the bar in 2002, and later in 2006, he qualified as a solicitor of the Supreme Courts of England and Wales. His 20-year experience and knowledge of the legal sector is something that his clients and peers benefit endlessly from. Mr. Kiani was among our founding members and is one of our former presidents. I think there is no better person to talk us through ILA's objectives. Please join me in welcoming Mr. Sajjad Kiani to give his address.
Thank you very much indeed, Nisa Malik, for such a generous introduction. Iqbal says, because most of the gentlemen, ladies and gentlemen, speak Urdu as well and Hindi. Iqbal says, "Koi qabil ho to hum shane kahi dete hain. Koi qabil ho to hum shane kahi dete hain. ढूंढने वालों को भी दुनिया नहीं देती." Ladies and gentlemen, honorable guests, and esteemed colleagues, good evening and very warm welcome to you, all of you. It is both an honor and privilege to open the annual legal conference, which we do every year. Today is a very auspicious occasion for ILA, its members, and its particularly members from abroad who have joined us today through video links or in person, and we feel proud that we have a membership which is exceeding 4,190 members around the world right now, I think. So first, I would like to thank you for taking the time to join us today from your hectic schedules. I know it's long Easter weekend. Everybody might have planned for the holidays. But again, thank you for your graciousness to be here and among us, particularly, again, barristers, academics, students, and those who are our sponsors. Our sponsors are going to have a short speech at the end to introduce you their vital and pivotal services they are providing to all of the law firms. And we recommend you must listen to them, that make them help. So allow me to begin with briefly introducing the International Lawyers Association, which we fondly call the ILA. ILA is a platform that's been created for legal professionals from all corners and around the world. Our mission is simple, which is to connect legal fraternity around the world. And we have been successfully achieved that over the period of time. And we intend to promote harmony and legal knowledge among the legal fraternity of different jurisdictions. Today's conference and everything the ILA does is built around the main five objectives, which you're going to see very soon in the slides. We have five main core objectives. And the first one is, as I said to you, fostering links between the legal fraternity. And we have a presence in more than 30 countries, which is Commonwealth countries based on Commonwealth basically. And you know that since the Magna Carta, that's the law which is prevalent around the world at the moment. And that presence is very, very significant. Particularly, I'm coming from, I have a roots in a common law country. So I think that connection with the British roots and the judicial system is quite pertinent and very strong. And that's been substantiated in our day-to-day practices in courts in England and Wales. And we are promoting the essence and spirit of that common law around the world to make sure that we get together in simple words, it's called networking, and then promote that sense and a spirit. Well, the promoting the rule of law is one of our second main objective. The rule of law and the supremacy of law is one of the key components of any sort of society. In terms of CPDs and educational background, educational training, the ILA we have hosted Law Society President, many of you know Lubna Shuja, the first woman, Asian woman in 200 years of Law Society history. She has delivered key speeches along with other renowned barristers like John Pressler, you might have heard about him, and a number of other pertinent speakers in part about the regulations, management of the firms, and professional negligence. These are all CPDs we have delivered over the period of time, and that is free of cost. We didn't charge anything to anybody. And about the rule of law, again, the breaches a blatant disregard to human rights regulations, ECHR, and the government and bureaucratic control over the media, over the democratic institutions, and most importantly, influencing the judiciary and judicial system. That has been a core objective for the ILA, exert its influence in lobbying those who believe in democratic norms, values, and virtues around the world. ILA is apolitical. We don't support any political party and any political sort of right and left wing theory. We just believe in just an equitable system based on the common law. And those democratic values which we inherit through our own sort of systems, and particularly in the backdrop of, as I said to you, Magna Carta. So this is evolving democracies and evolving system and judiciary, of course, and then the media and the freedom of expression is all these are the core objectives, and where we see any breach to these core principles, we raise our voice to that effect. Particularly in we have seen that Ukrainian and Russian war, where the blatant human rights breaches have been committed. And we have raised our voice and we have taken various petitions to UNO and to the Russian consulates and the various other institutions. We think that may gonna have a tremendous and pertinent impact. So, thank you for reminding me because I'm going to go on and on. And the third and most important factor in relation to it is where the subcontinent is concerned. There is a judicial sort of I would say the judiciary has been under tremendous influence by various factions of the society, where they are either in the form of establishment or in any other particular form, but judiciary has consistently been under influence. I'm talking about one of the leading party leaders, Imran Khan, who has been I would say that who has been a victim of a judicial process. It has been under the, I would say unlawful detention for a long time. And ILA has raised members, and ILA itself as the organization raised their voice to uphold the democratic values. So now, again, as I indicated, stimulating legal education and awareness is one of the other forms and a core objective of ILA. As I indicated, CPDs has been our sort of a main forte over the period of time. We want our members to be either in legal accreditation or family, or immigration, normally the IC firms do. So we help our people with our friends and fraternity with a laxal awareness, with a standard sort of day-to-day practices regulations, CQS, and of course LLA legal contracts. In that context, if you have any inquiries, you can ask one of our members, and they'll be happy to extend their help to you. So in a moment, I'm just going to cut it short just because of the cut it short. Sorry, just because of the time constraint. We have another eminent speakers. I think you would love to listen to them, and I again welcome all of you. And in a moment, we will move to our first panel, which is our president. But before, I want to emphasize one pertinent message: the ILA is your own association. It exists to support you and to inspire you and to help you grow in your career as a lawyer and as a business and as a law firm. And see it as your family, and we are your family members. And if you would like to sign up as a ILA active or a passive member, we welcome everybody on board. So thank you once again for being here today. Welcome to ILA Annual Conference 2025. Thank you very much.
Thank you. Thank you, Mr. Kiani. Our next speaker is none other than International Lawyers Association's current president, Mr. Safdar Iqbal. He has a decade of experience as a solicitor and was called to the bar in 2023. Despite being principal solicitor at Solicitors Inn and managing two branches, one in Ilford and the other in Stratford, our president is someone who has wholeheartedly invested himself into ILA. He has been dedicated to bringing lawyers together from across the globe and has made some key advances in this regard. One of Mr. Iqbal's key traits as a leader is that he is able to recognize opportunities, bring together a team, and draw out the best in them. Steve Jobs was quoted as saying, "Great things in business are never done by one person, they're done by a team of people." The successes ILA has seen over the years is a testament to great teamwork. Please join me in welcoming Mr. Safdar Iqbal, President, to say a few welcoming words.
Thank you very much, Moshe, for such a gracious introduction. Distinguished guests, esteemed colleagues, members of International Lawyers Association, ladies and gentlemen, Good afternoon, and welcome to the ILA Legal Conference. It is a true honor to stand before you today as the president on this of this esteemed global association. I'm humbled and proud to open what promises to be an inspiring and impactful gathering of some of the most brilliant legal minds from around the world. Let me begin by extending my warmest welcome to all of you, whether you have traveled across countries and continents or you are joining virtually. Your presence here reflects your commitment not only to the legal profession, but to the shared ideals of justice, ethics, and global cooperation. This conference is more than just an event. It is a meeting of vision, of purpose, of resolve. It is a testament to the fact that love knows no borders, that we are all bound by the values we uphold, the truth we seek, and the justice we defend. I wish to offer special appreciation and gratitude to our ILA office bearers across the globe and in the country, United Kingdom. From the America to Europe and from the Asia to Africa. Your work has been nothing short of remarkable. Each of you, in your own vision and capacity, has upheld the dignity of the legal profession, fostered dialogues across cultures, and advanced our mission in challenging times. Whether it was through mentoring young lawyers, leading legal reforms, responding to crises, or simply ensuring that the rule of law never faltered in your communities. Your dedication has directed this association to a truly global family of justice seekers. Let's take a moment to recognize their tireless efforts. And let's do so not only with applause, but with our continued support, respect, and collaboration. I would kindly request, please give a huge round of applause to our office bearers in the UK and across the globe. Now let's talk about a little, because I know the key speakers are here. They will shed the light on the main topic. But let me do some touch base. Now, as we gather today, it's a fitting that we also reflect on the principle that guide us as a legal professionals. In particular, the SRA principle of legal practice, which rooted in the UK framework, embodies values that resonate with lawyers across the world. These principles are not just guidelines, they are ethical cornerstones to uphold the rule of law and proper administration of justice. This is our high calling. In every courtroom, every negotiation, every consultation, we are custodian of fairness. The rule of law is what separates democracy from chaos, rights from oppression, justice from tyranny. To act with integrity in words filled with gray areas. Our integrity is what keeps us grounded. It is what allows society to place its trust in us, to believe that we will speak truth to power, even when it is uncomfortable to do so. To act in best interest of our clients, but not just clients. We must also serve the public interest, upholding a justice system that is accessible, fair, and independent. To act with independence, free from influence. This is especially for Mrs. Shoaib Shaheen. I think we must include in our Pakistan's judicial system. Free from influence, free from fear. Independence is not just a privilege, it is a responsibility. It ensures that our advice is not swayed with politics, profit, or prejudice. Then to act with honesty. Without honesty, our profession cannot survive. It is the thread that weaves through every oath we take, every judgment we make or argue, or every decision we make. To maintain high standard of service, competence, and diligence. The law is evolving and the world is changing. And we must raise to meet and with knowledge, agility, and unwavering dedication. And finally, to ensure or to encourage equality, diversity, and inclusion, the law must serve everyone, not just the privileged, not just the powerful. And that means building a profession that reflects the people it represents. We must not only accept diversity, we must champion it. These principles are not limited by the jurisdiction. They are human values. And as a member of the ILA, we carry them across borders, cultures, and systems. We live in a complex times where technology outpaces legislation, where conflicts test our compass, and where access to justice remains uneven. But within every challenge lies an opportunity to build stronger legal frameworks, an opportunity to support the next generation of legal leaders, an opportunity to remind the world that law is not just about rules, it is about responsibility. As we embark on the session ahead, I encourage each of you to bring your full selves into the discussion. Let us challenge ideas, share innovation, question assumptions, and most importantly, let us build connections will lifelong after this conference ends. Together, we are not just shaping the legal profession, we are shaping the world's future. One principle, one case, one person at a time. Once again, welcome to ILA Legal Conference. Let's make this a milestone in our shared journey of justice, integrity, and global unity. Thank you very much. Thank you.
Thank you, Mr. President. Our next speaker is Stuart Stevens, who is head of Holborn Chambers. Mr. Stevens has vast experience in both civil and criminal jurisdictions. In terms of crime, he is a defense advocate who has been involved in some very interesting cases that have even attracted national media interest. For example, he was leading junior in the Brinks-Matt money laundering trial. And for those of you who don't know, that was the largest gold heist in British history. He was also involved in Darkir, the Euromat case, for allegedly supplying nuclear triggers to Saddam Hussein. It is also of considerable note that Stuart has led several murder trials but has never had a conviction for murder. One of his recent cases, R versus M and Oz, was in relation to a Tamil gangland double beheading murder. His client was acquitted on submissions because of flaws exposed in the cell net evidence. It is a great honor and privilege to have such a great legal mind here with us today. Please join me in welcoming Mr. Stuart Stevens to give his address.
Good evening, ladies and gentlemen. I don't know who should be talking about. What do you mean? No. Actually, I'm delighted to be invited to speak tonight, particularly as I'm from the other side of the profession. Normally, I charge a decent fee, but it appears that Ghulam Mustafa is very persuasive and got me here for nothing. Anyway, to cut a long story short, I'll take up from what your president just said about the influence of AI. I think that's what you're referring to on the legal profession at the present time. The role of artificial intelligence in legal practice and how it intersects with our core professional duties is quite complex and is increasing all the time. We know our duties well, upholding the law, maintaining public trust, practicing with honesty and integrity, acting in the best interests of our clients. I'm sure every single person here, and indeed all barristers, know that those principles and hopefully adhere to them as close as possible, with never misleading the court. So where did AI come in? AI comes in because it shortens matters, doesn't it? Instead of doing hours and hours of legal research, you press a button and there it is. But there's huge dangers in that because AI, first of all, can be influenced, and it gets influenced by how many hits it gets, etc. And therefore, you could end up having a very biased view from AI. It's never an excuse to be able to say about AI, oh, well, I was relying on AI. And the judge will say, I'm sorry, you're the one who's responsible. Take another example. As we go ahead in years to come, if we have AI in courts, you'd have AI interrupting, especially as I know some of you are from overseas and not born in this country, and they'll be correcting odd little bits of your English, saying, that's not right. You should have said it this way, and you said should say it that way. And imagine if it goes further. Imagine if we have AI judges. AI judges deciding this on the balance of probabilities in the county court is this. And how much damages? Well, I've looked up 1,001 cases, and that's the damage you should get. Not looking at the individual case at all. And take a criminal case. If the AI has to decide on the burden of proof and whether it's been proved beyond reasonable doubt, they'll do it on a percentage. Now, can I tell you something? There's been research done on tossing a coin. And if you toss a coin, 70% of it will either land on heads or tails, not 50-50. And that's the result of scientific research. So it's very dangerous to ever rely on AI. And this is something that is important because imagine a busy firm like some of you have, and you want to do a research, etc. You press the AI, you get it all out, you tell your client actually thinks it's you, unless you have the honesty to say, well, actually, this is AI, and I just tinkered with it a bit just to add your name and put A and B at the end. But the final responsibility is always yours because, as I said, we have the integrity, we have the responsibility, both to the court and the client. And the technical advantages that AI gives can be outweighed, in fact, by too much reliance on it. Consider confidentiality, one of the pillars of our legal duty. AI tools, we know, are presently efficient, but they also leak. Your confidential information, which you're bound, of course, data security isn't optional, could be spread. So the danger about AI is, while very, very useful tool, and this really is for the younger practitioners, because by the time our AI really approaches it, some of us will be long gone. But when it becomes very, very powerful in society, young solicitors and barristers will just think, oh, well, all I have to do is press a few buttons and there we have the answer. And that would be detrimental not just to our profession and our professional duty and our professional duty to the courts, but also to our integrity as lawyers to research and look after our clients to the best interests with our personal knowledge. I'm not going to take long because it's a subject that will grow and will grow with all of us as time goes by. I hope it's been an interesting talk. I'm not talking as long as the other gentleman because one was your president and the other was the one who introduced you. Thank you very much for listening to me and a very good evening.
Thank you. Our next speaker is Mr. Afzal Zami Sayed Ali. Mr. Sayed Ali was called to the bar in 2011 and has a mixed practice covering fraud and complex litigations. He is currently a tenant at 33 Bedford Row. During his career, Mr. Sayed Ali has advised EU Observer Mission to Bangladesh as a specialist on electoral laws, regulatory reforms, and security and public order enforcement issues. From 2008 to 2022, Mr. Sayed Ali was in the Organization for Security and Cooperation in Europe expert database of international political and electoral observers. He was trained by the ICRC and UNHCR on the laws of international and non-international armed conflict. His notable cases include being led in a murder trial, R versus Abdullahi, and being led in a high-value fraud trial involving systemic abuse of immigration work permits. Clients were acquitted in both multi-defendant trials. Please join me in welcoming Mr. Afzal Zami Sayed Ali to give his address.
Distinguished guests, ladies and gentlemen, and Safdar Iqbal, the president of ILA. Thank you very much for giving me the privilege of coming here today. This is the first time actually I came inside the building of the Law Society. I'm scared of this building. Those fearsome lawyer solicitors who often instruct me. The latest engagement that I've taken in line of my international work is I'm the consultant legal advisor to the Corruption Task Force in Bangladesh, reporting on a corruption white paper on the previous government, the government that toppled on the 5th of August. In terms of the law or the best practice, the 10 points that you have seen in the brochure printed in front of you, the relevant part of my practice is that I do often defend solicitors in SDT trials. In the last 12 months, I defended only 2, and both successfully with an agreed outcome where they were not reported. In terms of the ideals, the morals and the ethics of a lawyer defending a client, one aspect that is not mentioned often in printed material, but it is part of the daily life that we experience in practice, is that we defend our client by all lawful means. Lawful doesn't mean it is simply lawful. It has to go beyond that. The next word, often we don't quote or mention, is that it has to be proper. Recently, I faced a situation where I had the option to go cutthroat on a co-defendant, or I can simply cross-examine on certain aspects of the evidence without having to go to do the cutthroat. Now, I felt that this is it's not proper to go cutthroat. It's not easy. It's not right decision unless it's the absolute last course of action. I don't prefer a cutthroat defense. It's a 4-defendant issue. One of the defendants decided to go cutthroat, taking the decision away from me. But I chose not, even then, I chose not to go for cutthroat. Buried in the 33,000 pages of documents, I had my client's bank account was mentioned between the 2 other co-defendants. And therefore, my jury speech came to less than 5 minutes, simply asking if you think that you can convict properly based on the fact that I did not forward my bank account for this corruption, that 2 other people unconnected to me were exchanging my bank accounts. That's reasonable doubt. They couldn't convict. We didn't have to go to a cutthroat defense. So it's a judgment call if you decide what is proper, and therefore lawful by all lawful and proper means. We defend our client, and that is a different set of perspective and the vision to look at the case, because I'm on the bar side of things. Part of the solicitor is that a solicitor gets personally invested in the story of his or her client. And therefore, for them to look at dissociating with the client's own personal judgment of the case, it sometimes becomes difficult. And therefore, you face the front line of that moral judgment, that question. Do you separate yourself from your client's case and take a professional view on the litigation aspect of things, based on which you then instruct your counsel, which we don't face? We are a step removed from that moral challenge, and therefore that makes a solicitor's job that much more hard and difficult. That is one aspect of practice that you must bear every day in your mind with every client that you face. And therefore, one of the things that I had in mind to suggest today is that ILA can be a platform where they provide some sort of protection to their members when they face this type of disciplinary tribunals, assistance in management practice, so that this doesn't happen. This is from a wide range of experience that I have defending in National Nursing and Midwifery Council, General Medical Council, and the SDT. These are the right sort of organizations which can have 2 sorts of platform. One, for its members' internal readiness for their practice and compliance, and externally for their expansion of business. And of course, this is an international lawyers association. This is based in UK. Maybe a way forward for next way forward is to open up chapters in other countries and then truly have a global association of lawyers, which would then exchange programs and ideas. Thank you very much for inviting me. These are the things that I had in my mind to share with you. I hope this has been helpful. Thank you.
Thank you. Our next speaker is Mr. Razi Shah. Mr. Shah qualified as a solicitor in 1997, as a solicitor advocate in 2004, and was later called to the bar in 2022. In 2006, Mr. Shah became the first Black, Asian, and minority ethnic to be elected from a geographical constituency to the Law Society Council in 2006. He served on this council for 16 years. In addition, Mr. Shah has served as the chairman for the Law Society Scrutiny and Performance Review Committee. His primary role was to ensure office bearers, including the president and chief executive, acted within their powers. In 2009, he became the first Black, Asian, and minority ethnic and youngest ever legal member of the Queen's Counsel Appointments Panel. In 2010, Mr. Shah was appointed as Deputy District Judge in the civil and family jurisdictions. From 2011 to 2013, Mr. Shah served as President of the Berkshire, Buckinghamshire, and Oxfordshire Law Society. And most recently, in 2023, he made history once again by becoming the first barrister to be elected as President of a local law society. I have only mentioned a few of Mr. Shah's key achievements, but I'm sure we can all agree that his legal career spanning across 3 decades has been impressive. I'm sure he will have much to share in relation to our topic today. Please join me in welcoming Mr. Razi Shah to give his address. Thank you.
Good afternoon, ladies and gentlemen. I was told I was first on the list, but when I saw the list and saw Stuart Stevens was speaking, I asked to be bumped down after him. Out of respect to Stuart Stevens. I remember when I joined the profession, Stuart Stevens was one of the senior members of the bar and the man to go to. And I've had the privilege and pleasure of working with him on many an occasion. And may I say, he still looks the same, except for a few extra pounds that he's put on, both on himself and no doubt in his pocket. And hearing the work that he has done, it is right. I had the pleasure and benefit of working with some leading lawyers in England and Wales, including Sir Lord Justice Adrian Fulford QC, Paul Pennell QC, many others. And whenever I wanted to pick who was going to be on my team, I would look at the case and I'd look at what that particular case required and who had specific personality and talent. And whenever I had one of those cases, and as lawyers, we've all had the ones we call no winners, no chance of winning, I always thought of Stuart Stevens. Lo and behold, he would always come through. He would always come through. I merely mention this because he is a grandee in the profession. He's senior. I haven't seen him for many years, and I just feel honored to be speaking on the same podium as him. But by way of the talk that I've been asked to do, this is the bicentennial year, the 200 years celebration of the Law Society of England and Wales, and you sit in this grand room. And this is a body that was responsible for both governing these solicitors in England and Wales and representing them. And in fact, my very last speech as council member at the Law Society here in 2022 was on the rule of law to the council members, president, deputy president, and the office holders. And this is my first time back since then, and I have a lot of deja vu. This society has always acted in the best interest of the public as well as its members, and did a lot of work in relation to that. And I'd like to share a few stories because I know we sometimes get bored with the actual legal topics. So let me share a few stories. The first time I was elected to the council, and council meetings used to take place in this room. So I entered the front doors and I was stopped 4 times before I got up here, saying, "Who are you? What are you doing here?" And I discovered by the end of the meeting why I had been stopped 4 times. Because I walked into this room, I was the first person in 186 years, as it was then, to be elected to this council who was non-white. And I got stopped 4 times before I got upstairs. So can you imagine seeing so many non-whites in this room now for me? I never thought we'd get to this stage, but we have. This society believes in diversity and inclusion, and you are the primary examples of it. You're all members of this profession, and that is how the law society sees it, and that is how the public should see it, and does no doubt see it. And that brings me to the principles that I have been asked to talk about, and those are the SRA principles in relation to how we should conduct ourselves in the profession. The principles, and there are 7, and I'm not going to speak on all of them. By way of background, these came about around 2010, 2011, if my memory serves me right. Prior to that, we had the Solicitors Act of 1974, which governed how we conducted business, how we represented people, and how we acted. And the previous rules were good because they were set out in a code of practice. There was a book this thick, I still have it, and it's set out in black and white exactly what you could do and what you couldn't do. So you knew what your position was. You knew if you did something which wasn't permitted according to that book, you were in trouble. But the current principles are different. Because on the one hand, they were introduced to make life easier in an ever-changing world, in the legal professional world. But on the other hand, sometimes I do wonder who they will make easier for the solicitors and the lawyers, or for the Solicitors Regulation Authority. Because these current rules, compared to the previous ones, are outcome-based. So what they say to you is, here are our principles: rule of law, administration of justice, honesty, integrity. But they don't tell you specifically what you can and can't do. Outcome-based rules are this: you do what you think is right, but if it goes thumbs up, Stuart Stevens, pear shape, thank you. I think you used thumbs up in a closing speech once, but if it goes pear shaped, you're in trouble. So they put the burden on the solicitors to determine what they can do and what they can't do, what is right and what is wrong. The additional problem with that is the guidance they give you. The guidance is very minimal. In fact, the last time I looked at it was when I was lecturing the profession on behalf of the society, when these rules were going to come in. And at that time I said, if you're not sure, go back to the Codes of Practice and Solicitors Act 1974, dig up the book and look in that as to what you can and can't. But I thought now, 13, 14 years on, we might now know how these have embedded themselves and what we can and can't do. So I went to the SRA website to have a look. And I must say, other than a couple of examples under each of them, they still leave it very much open to those practicing to decide what they can and can't do, what is right and what is wrong. So if everything goes right, you're okay. No one's ever going to know about it. If something goes wrong, you could be in big trouble. Now, the other problem with these new core principles is that they are not just about what work you do from your office. Which area of law you practice, whether it be conveyancing, family law, criminal law, it's not just about what you're doing, representing that client, conducting work in the office, going to court. No. It also takes into account what you do in your personal life. And this is a sign of the changing times and the changing matrix, perhaps what these rules were designed to do. But what you do in your personal life outside of your practice, why is that relevant? Well, it's relevant, the SRA and the Law Society will tell you, is because it goes to integrity and honesty. And it is right that in this country, the legal profession has always been considered to be of the highest ethical standards. And we've been very proud of it. And I'm proud to have been a member of this profession for the last 3 decades. But what the SRA says is, if you do something in your personal life which affects integrity or honesty, and then we will be able to use that in punishing you in your professional life. So that may seem a bit unfair, but it is to maintain the reputation of the entire profession. And in this particular day and age, it is very difficult because our lives are all over social media. We don't realize. We will view things, we will comment on things. We will go to sites which perhaps are not something that the profession will accept. And one very recent public example of that is of the Deputy Chief Magistrate of England and Wales, who was given a warning, and the entire judicial profession has been given guidance on what they can do on social media, affecting literally what they do in their private life. So how does that fit in with the core principles? Well, some of these have different standards, moral beliefs, cultural beliefs, religious beliefs. And one may think that those may cause us a problem. Those may not fit in. How will we know what is right or wrong? Well, I always thought that if we followed the traditional moral beliefs, we followed the law, we acted with integrity and honesty, then there should be no problem. But of course, there is no specific guidance of what we can do and what we can't. So let me just deal with 3 examples. Uphold the rule of law and administration of justice. How do you do that? Well, the rule of law, you think, is about the rule of law. I mean, this society has always supported the rule of law both in this country and abroad. And when you think of administration of justice, you think, is it litigation? Am I to do things properly, not lie to the court. I'm an officer of the court, do things on time, file statements on time. Well, no, this particular principle doesn't deal with that. And the examples it gives you of what it does deal with is two examples on their website. One is of a lawyer attending a climate change demonstration. And that lawyer attends a peaceful demonstration, and when asked, peacefully leaves the demonstration. That would not attract the harsh penalties from the SRA. You wouldn't be before a solicitor's disciplinary tribunal necessarily. Well, this particular solicitor who did attend didn't get punished. And the SRA said, well, we appreciate that some people hold strong views about climate change. But if you act within the law, you can do that. Against another example of a solicitor who attended a climate change demonstration and when asked to move on, wouldn't move on. The police decided they would arrest him, and he resisted arrest. That's all demonstrators do when we've seen this on TV. They park themselves on the floor, or they grab onto railings, and when being asked to move, they don't move because they want to demonstrate. So the police charged them with resisting arrest. The SRA decided that was a breach. That deserved punishment. Took him to the solicitor's disciplinary tribunal. Fined him. Had a mark against his otherwise perfect record. So that is rule of law and administration of justice. When you look at it, don't be misled as to what you think it means. Because when I looked at it, I thought rule of law. And I thought, speaking out against the government's policies, so on and so forth. But that is not what it means for you as professionals. And in fact, I do now wonder how it would have affected me, because I attended a demonstration, funnily enough, on behalf of this profession. Most of you will know that in Pakistan, the Lord Chief Justice was removed from power by the then President and Chief of Army Staff, General Musharraf, and there was a movement to reinstate him. And the Pakistan Bar Council sought support from other governing bodies around the world. So they wrote to the Law Society of England and Wales and to the Bar Council of England and Wales seeking support. And the then president of the Law Society, who was very much a believer in the rule of law, decided, yes, we must support the reinstatement of the Lord Chief Justice. And how are we going to do it? Well, he decided we'll send a representative. And he duly picked a representative to go on behalf of the Law Society of England and Wales. And that, named for the slaughter, was me. So I ended up going to Pakistan. I was there for the Long March, and I was the recipient of the police action, the tear gas, the baton attacks, so on and so forth. And I proudly say I did hold my ground. I didn't run. I stood. I took the punishment, pushed back a little bit. Would that be breach of this rule? Who am I pushing back? Would? I may have been standing up for the rule of law. But my actions in breaching what was a banned march, a banned gathering, and pushing back at the police would have held me in breach of this law. I can say it now. Number one, because as Stuart and all of you colleagues will know, that rule didn't apply. This rule didn't apply then. We had a different rule. And secondly, luckily for me, it was outside of the jurisdiction of England and Wales, although I'm pretty sure SRA would bring it in, that you were a representative of this member of the profession. So that is the kind of example you need to bear in mind as to what you do in your personal life, which would reflect and perhaps incur the punishment of disciplinary proceedings. Example of the other core principle, act with honesty and integrity. Well, I think that is simple enough, straightforward enough. We all know what is honesty. We all know what is not honesty. But what guidance do they give? Because there's honesty and there's integrity. And the guidance the SRA gives is, well, if you do something wrong and we think we can't get you on dishonesty, we may still be able to get you on integrity. And the only example they give of proceedings under this rule are of a solicitor who was ordering goods by mail, as we all do shopping by Amazon and other things, and would receive these goods and then return them. But returning them would be different clothes, but the tags changed. And they said that was dishonest. So you're acting dishonestly. But what is integrity? Integrity is an entirely different thing. And the last example I'd like to cite is the one where they say you act in the best interest of your clients. Well, that's the core principle. The problem I have with that principle, and one that you need to bear in mind, is if you look at the guidance, it says it's not just in the best interest of your client currently, but it must also be in the best interest of former and future prospective clients. So imagine you're representing a client and he's in a transaction with one of your former clients. And he's getting a better deal. And you're saying to him, oh, you're getting a real good deal here. You know, you're doing him out of a good deal, a fair deal. And he's one of your former clients. What do? The rule says it's going to be former, present, and future prospective clients. Well, to be perfectly honest, I know not the answer to that. And I don't think the SRA does either, because they don't give any examples as to how you should deal with this. So let me tell you in closing, as I was told when I attended my first day at my law firm, and my principal said to me, son, there are 3 golden rules you must remember. Here we go. So never ever forget these 3 golden rules. Rule number 1, never trust a client. That's right. Okay. Rule number 2, he says, never trust a client. Okay, something's coming here. Rule number 3, never trust a client. Roger Russell, Stuart Stevens will remember him from a long time ago. And there is sense behind that. The sense is this: your clients will tell you something, you have to act in the best interest, but you must do it with integrity. Don't be misled and walk up the wrong path, just trying to please them and get the best for them. And the other rule, which was the primary rule that I learned, is whenever you write something, whenever you represent something, even if you're not in court, each letter, each email, each representation, when doing it, remember in the back of your mind this: what if this ends up before a judge? How will he view it? How will he read it? And will he think I acted badly, properly, honestly, and with integrity? So if you can remember that, I think we will always be fine. Thank you very much.
Thank you. Our next speaker is Mohammed Shuaib Shaheen. Mr. Shaheen has an impressive 32 years of experience as a lawyer in Pakistan. He is a civil lawyer, currently serving as an advocate of the Supreme Court. During his impressive career, Mr. Shaheen has been elected president of Islamabad High Court Bar Association and held offices in the Islamabad Bar Council and the Pakistan Bar Council. He is passionate about the ideology of rule of law, following the Constitution of Pakistan and the need for justice to prevail in Pakistan. It is to that end he actively takes part in press conferences with top leadership and is an active member of Pakistan's political party, Tehreek-e-Insaf. Notably, in 2024, he stood in the elections as a candidate and won by a landslide. However, unconstitutionally, his constituency was given to another political party. Mr. Shaheen has stood against rigging and unconstitutional steps taken in Pakistan. While International Lawyers Association is not a political organization, we acknowledge the importance of rule of law. Please join me in welcoming Mohammed Shuaib Shaheen to give his address.
Iqbal. I'm thankful to ILA directors, Mr. Safdar Iqbal, Mr. Mohsen Malik, Mr. Sajjad Kiani, and Ms. Isa. Thank you for my introduction. Distinguished members of the International Lawyers Association, respected colleagues, jurors, learned friends around the world, ladies and gentlemen. I am truly honored to speak before you today. It is a great privilege to be among such a respected gathering of legal minds who continue to protect and promote justice and rule of law around the world. The core principles and the duties of legal practice in the UK and Pakistan are similar. That is, upholding rule of law and administration of justice, independence and dignity of our profession, and to struggle for independent judiciary. When we demand rule of law, it means the law is the supreme authority and everyone is bound by it. All individuals and institutions must be treated equally under the law, regardless of their status, influence, and the wealth or power. Justice system must be fair, impartial, independent, and the independent judiciary must protect the fundamental human rights and promote the transparent, equality, and accountability. Rule of law guarantees the democracy, freedom of speech, freedom of assembly, and human dignity and professional trade. Today we live in difficult and uncertain times. The rule of law, the foundation of every free and fair society, is being tested. Trust in institutions is falling in many countries, including minority countries such as Pakistan. People are demanding justice, fairness, and real democracy. As you know, and proud of my free bar solution of Pakistan, I have seen how legal systems are struggling to keep up with the challenges of our times, whether it is protecting basic fundamental human rights, defending democracy, Ensuring justice is equal for all, and the judiciary is independent and delivering justice without fear of being not representative of the opposition party that has support the people of Pakistan. I gave to you not just as an order, but as voice of movement for justice, rule of law, true democratic change, and real freedom. The people of Pakistan is through their voice. They chose the accountability, justice, and constitutional rule. Now, it's not easy, even after the victory. The government forces restricted the change and accountability, and the consequence thereof, our success was not accepted, and the result was manifestly changed. Our efforts did not harm, as pointed out by Mr. Gyani and Safdar. The very popular Pakistan was differently, and we were 250 bonus cases were registered against them. Counting the workers are arrested due to political victimization. Almost all members of the National Assembly, provincial assemblies, senators, chief minister, and ministers of governments, all belong to the party, and all stakeholders are facing hundreds of false and bogus cases while abusing the process of law. There is no freedom of speech, no freedom of no freedom of protest, and hundreds of protesters face indiscriminate firing, and our captains are on 26 November 2024, and some are dying and some are injured. And instead of taking an action against the real culprits, thousands of the innocent protesters were killed, and they were sent to the jail. And not only they were sent to jail, and some of them are still behind the bar, and they are facing the illegal and false cases. Law and order situation has become wrong in our country because of all enforcement agencies and institutions are facing against the political workers of the largest and most popular political party, that is PTI. Our independent judges are facing acute difficulties and harassment, including the kidnap of their close relatives and installation of secret cameras in their bedrooms. I myself was picked up from my office and was sent to jail, and still facing 20 bogus cases registered with the government after being elected as member of the National Assembly. 97% of the terrorist cases are pending against political workers in the ABC, and only 3% cases with the terrorist cases are against the actual terrorists. House raids, abduction, damage to the houses, properties, offices is the routine practice of the law enforcement agencies. Therefore, working with the United Nations have declared the arrest of Mr. Imran Khan as arbitrary detention. After that, controversial 26th Amendment has compromised the independence of the judiciary and criticized the judiciary. This amendment was passed by unelected persons. When I say unelected, it means they are 447, which was made illegally and unlawfully within the law. There are includes and the Constitution, Elected Commission of Pakistan, supported by the mighty establishment. And cases are still pending to go to tribunal, which have now been changed and sent to the hand-picked tribunals by the most controversial Election Commission of Pakistan and the and our mighty agencies have used coercive tactics, including the attempting lawmakers to pass the most controversial amendment. The ICJ, International Commission for Justice, has expressed the concerns that this amendment has undermined the judicial independence, the rule of law, and human rights protection. The rule of law has become even more important as we are here to defend dignity and to stop injustice. The ground principle of judicial independence, press freedom, and confidential right are protected. These are not just political slogans. It is daily reiterated by us. It is a duty of man, judges and defendants of justice to stand up for right. Let us remember, law is not just about punishing people, it is about protecting them. Justice is not just about power, it is about fairness. Democracy is not just winning the elections by hook or by crook, it is about respecting the will of the people every single day. I ask you all to join hands with us to support the nation that is not moving with justice, transparency, and rule of law. Let us work together to protect democracy, human rights, rule of law, and to ensure that justice is not only for the job for everyone. I thank you for your commitment and your lead and Pakistan, Zindabad, law, justice, and the law to protect it. Thank you again.
Thank you, Mr. Shane. I know ILA is not a political platform, but I appreciate Mr. Shane sharing some of the concerns that are being faced in Pakistan and the importance of the lawyers and the rule of law and what role that plays among the masses in Pakistan. Our next speaker is Mr. Gulnawaz Khan. Mr. Khan is a director at Addison and Khan Solicitors based in Ilford, Greater London, and Nelson, Lancashire. He qualified as a solicitor of the Supreme Court of England and Wales in 2009 and now has over a decade of legal experience. Originally an entrepreneur, it was his passion for justice that encouraged him to join the legal profession. He is respected for his knowledge and dedication. Please join me in welcoming Mr. Gulnawaz Khan to give his address.
On a lighter note, when we say something about dedication, we all witness here that when we were coming, especially in central London, the roads are quite empty. I would say that, but you can see that due to it's a long weekend, it's the Easter holidays, but our hall is full, and this shows your dedication, your commitment, and a round of applause for all of you. Thank you. Our fellows from different jurisdictions, for example, Pakistan, India, when they visit our law firm, very common question what they're asking. Most of question, I believe, must be addressed today in our annual legal conference managed by International Legal Conference. So a number of questions have been asked, and the most of it is managed and addressed by Solicitors Regulation Authority in 7 principles. So our colleague, senior colleagues and learned friends have already lightened all of them. And I would say that our president, Safdar Iqbal, and other office bearers. So they have done a lot of work, especially when another colleague, Mr. Kiani, was saying we have over 4,000 members across the globe now. And some of the members from other jurisdictions, they have visited this, especially for this conference. They came all the way from thousands of miles just to attend this conference. I, as a president of International Law Association London chapter, I also welcome them. When we talk about the 7 principles, so most of been already addressed. And these are basically the core, and it is a duties which we must have to adopt as a legal practitioner. When I talk about just one topic, one matter, integrity. So when we are saying about integrity, so to me, it is doing something right when someone is not watching you. When you are giving advice to client, and we know that client doesn't know, but it is our duty that we tell, regardless that it is not been accepted by the client or it may not hear, but our duty, you must tell what is actually your duty as a lawyer. Doesn't matter it is against you or against you, because sometimes it happened number of times when we, after listening client's matter, and we know is this client does not qualify for this, if little bit favor we can give to us, but it is not favor of the client. So we must decline that. We must intimate the client that this thing is this hurdle, this problem you may face in the future. And especially in SRA, Solicitor Regulation Authority, this is our also duty that when we are taking any instruction, we must write to the client telling who is dealing your matter, what your instructions are, about the chance of success, how much your fees is, all that. And these notes I'm mentioning only for our learned friends or our colleagues that came from different jurisdictions. We are all living in a time, and this is changing time, especially AI. Another friend was telling that this is the nowadays drafting is just about to make some clicks and the draft is ready. It is up to you how you give very nice instructions to ChatGPT, and within no time you will see a very good draft in front of you. But same time, this is again the main thing is that okay, after proofreading, what we are saying, what the best interest of client is, not relying only on that. This is the main thing is our right knowledge before we making any representation. This is also duty that we must take a formal instruction and write research on that, and we prepare all this thing and not relying only 100% on AI. We totally understand AI in its early stage, but we can see that in next 5 or 6 or 10 years or after decade where AI will be. It's quite possible because we're learning, we're hearing that even operations being conducted through AI from remotely. It is quite possible that in the future maybe judges from by the AI. So this is we have to be ready for all that. Doesn't matter what the time changing is. We totally understand that rules we can read in book, but your integrity must be, you can see by actions. So thank you very much that you are coming here. Another thing before leaving, that we all gathered here, this is basically something we are here, that what we have learned from the conference, what we have learned from there, and what we are learning from here, these are the core principle, best interest of the client. And same time, another colleague was saying that when we no, don't trust on your client, don't trust on your client, don't trust. Because this is no negative things. The main thing is when you are saying something, if in case if you have triggered something wrong, you don't know where you will end on that. So you consider your client because he is your judge. If something is best, he is your ambassador. But if something you have done wrong, deliberately or without knowledge, it may cause you a lot. Thank you very much for your time and thank you.
So our next speaker is none other than Malik Mohsin Toga. Mr. Mohsin Toga is a solicitor director at Law & Co Solicitors, a firm with 2 branches, one which is just a stone's throw away from here in Chancery Lane, and the other in Ilford, Greater London. On 1st May 2025, Mr. Toga will be completing 18 years in practice as a solicitor of the Supreme Court of England and Wales. He has depth of legal knowledge in a wide range of legal areas and can often be found representing his clients in various courts up and down the UK. Mr. Mosintoga was also one of our founding members, our first ever president, and served again as president in the year 2023-24. He has played a key role in progressing ILA to where it is today. Please join me in welcoming Mr. Malik Mosintoga to give a speech in relation to honesty as a core principle of legal profession.
Thank you very much, Lisa. My today's topic is honesty. I believe my colleagues, they explained it very well, integrity and honesty. I have a slightly, the different example. So how many of you have watched movie Liar Liar? In this movie, Jim Carrey has built a successful career as a lawyer based on lies. His son, disappointed from his lies, make a wish that his father could no longer tell lies. That wish came true. Jim Carrey learned that it feels so good to be true. And honesty is the best policy. Though this movie is a light movie and this is a funny movie, however, Solicitors Regulation Authority takes dishonesty very seriously. Let me give you a life example of dishonesty. Uh, this is a matter in relation to a senior solicitor who used a parking badge, a blue badge, to use parking. After having an argument with the parking attendant, he finally ended up in Solicitor Disciplinary Tribunal, and SDT decided to strike him off. That serious like the solicitor, a senior solicitor, lost his license due to a matter which may be for public has very minimal consequences. So the lawyers are, especially for lawyers, I mean, they're held accountable, and standard is extremely high. Uh, this honesty goes beyond our profession in our daily life. This goes back to what Nissa says earlier, being a lawyer is a way of life. Uh, President Law Society Lubna Shuja attended our previous one of the annual conference, where she mentioned a case in relation to a girl who was a solicitor, and she was working part time on a phone website. Though it sound very interesting part time employment, however, trouble started when this website mentioned solicitor. And she again ended up before Solicitors Disciplinary Tribunal, and they found against her. So this is all about lawyers' integrity and lawyers' honesties. So conviction rate, especially in STD, is so high that in 22-23, 99 cases they were referred to SDT. 23 solicitors they're fined, 13 were suspended, and imagine 63 struck off the roll of solicitors. The courts have indicated in Bolton versus Law Society that confidence in legal profession as a whole is more important than interests of one lawyer. Therefore, finding of dishonesty against a solicitor is likely to result in the strike-off. Many different behaviors may be considered dishonest. Say, for example, taking or using clients' money without consent, lying or misleading someone, such as telling a client that their case is going well when it has failed, knowingly bringing a false case to the court, helping other people to act unlawfully, such as by giving credibility to a suspicious investment scheme run by others, I have many examples during my people approach me to introduce a tax scheme or a third party, the sale. So for solicitors, this is a serious matter. Without due diligence, if they endorse any scheme, they're liable for that. Giving false information to firms, insurers, misleading a court or tribunal or a regulator, lying on a CV or misleading partners in their firm, uh, backdating documents, creating false documents. So the test, when considering if conduct is dishonest, there is two straight tests as per IV versus Genting casinos. The first was the individual's genuine knowledge or belief, and second, in view of their knowledge or belief at the time, was their conduct dishonest by the standard? And the standard is ordinary, decent people. So your honesty will go a long way in achieving your success, both personally and professionally, building relationships, your recognition, reputation, and your enjoyment as a lawyer. When people trust you, they're likely to cooperate, support, and recommend you. Thank you.
Our next speaker is Michelle Burke. She became a solicitor of England and Wales in 2023 and since has practiced in areas such as immigration, family law, and personal injury. She is also currently serving as International Lawyers Association's Additional Secretary General. Please join me in welcoming her to give a talk on independence as a core legal principle.
Thank you for that introduction. Thank you very much. Honourable guests, distinguished colleagues, learned friends, good evening. It is a privilege to address this esteemed gathering at our annual legal ILA conference, where minds from across the legal spectrum come across to reflect, engage, and inspire. Today, I wish to speak on the principle that sits at the very core of our profession, the principle of independence, as enshrined by the Solicitors Regulation Authority, SRA. Under Principle 3 of the SRA standards and regulations, solicitors are required to act with independence. It may sound simple, but in practice, this principle demands unwavering commitment, even in the face of pressure, persuasion, or personal costs. Why is independence so vital? Because justice demands truth, and truth demands courage, and courage is only possible when a lawyer is independent from influence, from bias, from external control. In our profession, independence means more than not being told what to say or do. It means being able to advise and represent clients solely based on the law, facts, and professional judgment, without interference from employers, governments, corporations, and even popular opinion. This principle protects not only the solicitor, but the very integrity of the legal system. Us, a solicitor who can't act independently is no longer a shield for their clients. They become a tool for someone else's agenda. In today's complex world, we see threats of independence come in many forms. Corporate pressure, where commercial interests attempt to override legal judgment, political environments, where legal practitioners are expected to toe the line, social media scrutiny, where fear of backlash can cloud professional advice. But our duty as officers of the court and custodians of justice is to rise above these pressures. We must speak truth to power, defend the rights of our clients fearlessly, and uphold the rule of law, even when this is inconvenient, unpopular, or uncomfortable. As members of the ILA, our role is even greater. We must lead by example, uphold our independence with pride, and support one another when that independence is tested. Let us reaffirm today that our loyalty lies not with the powerful, but with justice, not with convenience, but with truth. not with silence, but with the voice of the law. To act independently is not always to act independently is not always easy, but it is always right. Thank you.
Right, I think our technicians are still trying to resolve the issue with the link, but I think this is a very opportune moment to take a moment to thank our speakers for their input and insights. It would also be a good opportunity to thank a few of our gracious sponsors. I ask our key sponsors in turn to come forward and give a short address about their services and how this may be of use to the lawyers we have here today within International Lawyers Association and its community. Please join me in welcoming our first sponsor, Mr. James Melville Emsley, who is CEO of Hunton Indemnity.
Everybody, I'm James Emsley. Thank you for the introduction. I'm Director and Head of Professional Indemnity at Hunton Indemnity. Firstly, I'd like to say a big thank you to the ILA for having me here today. It's great to be here. And on behalf of Hunton Indemnity, I'm very happy to be one of the sponsors of this event. So, I'd like to give you a very brief overview of solicited professional indemnity. It's a complex, expensive, and sometimes stressful process to purchase. So I hope I can explain the key issues for you, which I feel would be, well, what is solicited professional indemnity and what it covers and who needs it, overview of the current PI market, trends, how you should apply and what is needed, and how insurers calculate your premium and review your risk. So what is solicited professional indemnity? I'm focusing on smaller end of the market here, so 1 to 6 partner firms, English and Welsh firms only. Scotland and Ireland have a separate market for this. Solicitor's PI is a mandatory insurance that all solicitor firms must buy, purchased by the firm and covers the firm as an entity for all work undertaken on its behalf. The PI protects the firm against claims made by its clients, accusing them of negligent advice, errors, and omissions. Provides compensation to third parties and also pays for the cost of defending a claim. The policy is extremely wide and covers extremely wide cover, which is demanded by the SRA via minimum terms and conditions, which broadly states that all third-party losses are covered, with very few exceptions. So every firm's PI policy, it covers the same regardless of the size of the firm and what the firm does. This is in the public's best interest, but unattractive to insurers, and this is what makes it expensive.
Sorry, Mike.
Maybe that's better. So an overview of the current market. There's some good news for you to report. After several years of hardening market conditions, the solicited PI market has started to soften, and this is happening fast. This is caused by the capacity in the market increasing, with new insurers coming in, generating competition on premiums, and importantly, insurers are also relaxing their criteria a bit to retain clients. Past 2 renewals, October and April, I've seen premium reduction offered of 5 to 10% client by existing insurers straight off the bat. However, I've seen clients obtaining bigger reductions from the wider market when they're shopping. So now many firms are moving insurers this renewal period, things that they should consider. Although coverage may be like for like from all insurers, some specific differences may apply. So check the financial rating of the insurers. I believe all are now rated insurers. There are no unrated insurers in the market. The run-up terms which change from insurer to insurer can be 200% to 350% of your annual premium. So this is a significant factor. and of course individual excess that you carry. So how should you apply? Well, the market is growing but remains very small, and every insurer has a different criteria of firms they will quote for. They also limit access to certain brokers, so you must ask your broker to confirm which insurers they can access for you and which insurers will be suitable for your firm and your profile, of which there may only be 2 to 3 insurers be willing to quote. So insurers can quote up to 3 months before the renewal, so don't leave this to the last minute. The best price will be achieved in time to serve the wider market, and I think 2 months ahead is what you want to look for here. Complete the full proposal form, don't leave any questions blank, and ask your broker for advice if you're unsure of the question. Get hold of your 6-year updated claims prints as soon as possible. This is provided by insurers on 5 working days notice, and your broker will obtain this. If you have a claim, provide a brief summary, explain what lessons have been learned, what risk management procedures have been adopted within the firm to prevent further claims. Insurers are looking for financial accounts now, so 2 years financial account plus management information with a profit and loss and balance sheet is required. Insurers are looking to declare turnover matches that declared within the proposal form, but also they're looking for profit of the firm. So how is your premium calculated? Well, premium is rated directly from your turnover, your work split, and your claims record. Each work type carries a different rating. For example, conveyancing may be rated at 10% of your fees generated from conveyancing, whereas crime may be rated at only 1% or less. So people always ask me, if I get Lextel or CQS accredited, may this reduce the premium? I don't think the insurers do see this and offer a discount for this. However, if you have claims, it will help to present the firm as a good risk and makes insurers consider quoting in the first instance. So, brief conclusion. Generally, it's good news for the market. It's a buyer's market. Find a broker who has strong relationships with key insurers and who can help you present your firm with a good proposal. Start a minimum of 2 months before renewal and ask them to obtain alternative quotes for you this year to get better premium. So I've previously been working for a large city-based broker for 15 years, specializing in solicitors' professional indemnity, and I'm now working at Hunton's Indemnity. So of course, I'd be more than happy to advise, give any help to anyone who may require this at your next renewal. So please do feel free to speak with me. Thank you very much for your time and for listening.
Thank you very much indeed. Our next sponsor is Chris Rumble, Director at Alternative Business Machines. Please join me in welcoming Mr. Rumble to give a short address on the services his company provides.
Good evening. Thank you, first of all, to Mr. Iqbal for inviting us as ABM to address you all today. And obviously to the ILA. We feel it's a real honour to be here representing ABM. What do? We provide copiers, printers, multifunctional products, anything from a desktop printer up to a full managed print service where we're recently, with a law firm, put in 16 machines across 7 branches with paper cut software managing this so that anyone can go to any branch, print on any machine, and they can check who's printing. They can stop people printing in colour, which is 10 times as expensive as black and white. So we are a Canon business partner. We're accredited by Canon to their highest standard, which is their gold dealer standard. We supply new and refurbished machines. We offer that on a purchase basis or a lease rental. And something that's quite unique to us, we do offer what we call an in-house rental. So if it's a new business that can't get finance, we will rent them on a monthly basis, a fully refurbished machine with the same running cost as a new machine. The task of myself as an account manager is to make sure you get the best return on your investment. So sometimes it's better to pay a little bit more for a bigger machine that has a much lower running cost than going out buying something that uses cartridges, because people buy those, think they've got a deal, bought a little printer for 300 quid, spending £200 a month on cartridges doesn't work. What makes us different to other dealers out there? Well, we've been going for 38 years. We were established in 1987. We're an owner-managed business, and we have a dedicated service team that are employed directly by us. We offer national service, and really it's the retention of clients that is really important to us. By offering good service, listening to what you want, we have a huge client base that we've retained over the years, and people come back to us time and time again. We don't lose clients. Well, very, very few. Everybody loses one along the way, but we retain the majority of our clients, and they come back to us time and time again. So what we do is we listen, we advise, we make sure you get the right product to do the right job at hopefully the most competitive price. So that's us in a nutshell. I know we've got other things to do, so I'm going to cut it short there. Thank you very much for your time. And once again, thank you. Enjoy the rest of the evening.
Father, lion of foreign country to be able to but unfortunately we were not again with Ghana. I think problem for sure. Yeah. Settle the law and something even people. Organization of warrior we should not always be always near protected the foreign in the warrior.
Thank you. I would like to thank Mr. Pir Masood Chisti for coming on and giving that brief address. I'd also like to go back to our sponsors and thank them once again for their input. I'm sure our attendees have found the information about your businesses useful and will call upon your services in the future. I know we have some limited time, so our last speaker is Sayed Afaq Hassan. Mr. Hassan qualified as a solicitor in England and Wales in 2021 and currently practices at Solicitors Inn. He also currently serves as Secretary General ILA Worldwide. Please join me in welcoming Mr. Hassan to give a few closing remarks.
Ladies and gentlemen, honorable guests, and dear colleagues, I will start with thanking our host today. She's been a wonderful host as always. I think without her, this conference may not have been that great. So I would like to have thank you very much. As we come to the end of this annual Legal ILA Conference 2025, it is my honor to thank each one of you for being here today and for taking part in what has been a truly special event. This year is important for two reasons. Not only have we had another successful ILA conference, but we are also proud to celebrate the 200th anniversary of the Law Society, a moment that reminds us of how far our profession has come. Our theme today, core principle of or duties of legal practice, has helped us focus on what really matters in our work: honesty, fairness, and respect for the law. I would like to give a special thank you to our speakers. Your time, effort, and knowledge made a big impact, and we are truly grateful. To all our guests, whether you came from the UK, Europe, Asia, Africa, the America, or anywhere else, thank you. Your presence here shows the strength of our global legal community and the importance of working together to improve the legal profession worldwide. Today, we have also highlighted the key goals of the International Lawyers Association: building strong connections between lawyers in different countries, promoting the rule of law, fast access to justice, supporting high quality legal education and training, speaking out against human rights abuses around the world. As we close, I invite all of you to stay involved with the ILA by joining our future events, training sessions, debate, dinners. Let us remember, being a lawyer is not a job. It is a responsibility, a duty to protect justice, help our communities. By working together across borders and cultures, we can build a better future for the profession and for the people we serve. Thank you again for being with us today. I wish you safe travels and great success in everything you do. We look forward to welcoming you to future ILA events. Thank you. Good evening.